Today we are taking up preamble of the Constitution. In the earlier classes we have seen what is Constitution, what are the various kinds of Constitution, what are the characteristics of Federal Constitution, and what are the salient features of Indian Constitution. Now we are taking preamble. Remember, there is no article number for preamble. In this class, we will see what is preamble, what is the importance of preamble, whether preamble is part of the Constitution. If it has no article number, how do you say it is part of Constitution? Though it is not a part of Constitution, whether it can be amended. If so, whether it has been amended. If amended, what are the words which have been included, etc. First thing we should remember, we should know, preamble is an introductory note of the Constitution. It outlines the objectives of the Constitution. It is the key to the minds of the founding fathers of the Constitution. Preamble reflects what we have thought and what we had dreamt during our freedom struggle. It walks before the Constitution. It is the pathmaker for public administration. And as we have already discussed, preamble has been taken from US Constitution. Preamble reads like this: We the people of India, having solemnly resolved to constitute India into a sovereign, socialistic, secular, democratic republic, and to secure to all citizens, etc., in our Constituent Assembly, this 26th November 1949, do hereby adopt, enact, and give it to ourselves this Constitution. So remember, this Constitution is adopted by the people of our country, for the people, and of the people. It is adopted on 26th November 1949. But it is effective from 26th January 1950. What is the importance of this 26th January? Because 26th January 1930, Lahore Conference passed a Purna Swaraj Declaration. To commemorate that day, we have taken the effective date of Constitution as 26th January 1950. That is a very important point, potential question. Now, second point you should remember is whether the preamble is part of the Constitution. Remember, there are two important cases which were decided by the Supreme Court. One is Perubari case in 1960, and another is Keswananda Bharati versus State of Kerala, 1973, which is otherwise called Fundamental Rights case. In the Perubari case, Supreme Court said that the preamble is not a part of Constitution because it does not give you any substantive powers. The substantive powers is already given in the body of the Constitution. Then what is the utility? Utility is when there is any clarification required, then you can refer the preamble. So it is not a part of the Constitution. In a nutshell, that is the decision of the Supreme Court. Then, this was reversed in the Kesavananda Bharati versus State of Kerala case of 1973. In this case, Supreme Court said, preamble is part of the Constitution, and the provisions of the Constitution should be read and interpreted only with reference to the preamble. And preamble limits the powers of amendment of the Constitution. See, there are three important cases decided by the Supreme Court with reference to the constitutional amendment. First case is, as you know, Shankari Prasad versus Union of India. Second case is Sajjan Singh versus Union of India. Third case is Golaknath versus State of Punjab. Fourth case is what is known as Kesavananda Bharati versus State of Kerala, 1973. Remember, Supreme Court in Shankari Prasad versus Union of India, as well as Sajjan Singh case, held that the Parliament has absolute powers to amend any part of the Constitution. In the last class I mentioned, Article 13, the state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. And if any law is made taking away or abridges any part of the Constitution, any provision in Part 3 of the Constitution, that amendment to the extent of repugnancy is null and void. So, categorically said, you cannot touch any provision in the fundamental right, Part 3 of the Constitution. That is Article 13. Now the question is, what is law? Law has been defined in Article 13 itself. Law includes, remember, law includes ordinance, act, rule, regulation, bylaw, anything which has the force of law. So the argument in the Shankari Prasad as well as Sajjan Singh case is, Supreme Court said the term law included in the Article 13 does not include constitutional law. It includes only an ordinary law, not the constitutional law. That was the interpretation of the Supreme Court in Shankari Prasad versus Union of India as well as Sajjan Singh case. Now read Article 13. The state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. If any law is made taking away or abridges any of the provisions of the Constitution in Part 3, then that law, to the extent of inconsistency, is null and void. So the term law used in Article 13 does not include constitutional law. This was the interpretation of the Supreme Court in Shankari Prasad, the Union of India, and Sajjan Singh case. Then came very popular case, landmark judgment case, what is known as Justice Subbarao, what is known as Golaknath versus State of Punjab. It is a landmark judgment. It turned the constitutional history of the country. In that case, Supreme Court held, Parliament has absolutely no powers to amend any part of the Constitution, let alone fundamental rights, because of certain reasons. What are the reasons they have cited? Number one, Article 368, which gives the procedure for amendment of the Constitution, gives you only the procedure, not the powers. They asked, where are the powers? You cite Article 368, but you read it. It is only procedure to amend the Constitution. Where are the powers? Number one. Article 13 clearly says that the state shall not make any law which takes away or abridges any other rights conferred in Part 3 of the Constitution. The term law includes constitutional law also. So you cannot touch. Number 3, Constitution was made by the Constituent Assembly. But here 17th Amendment, 1st Amendment, 2nd Amendment were made by the Parliament. And Parliament was elected only to rule the country. Where are the powers to amend the Constitution? So you cannot amend. Fifthly, Constitution has created Parliament. There shall be a Parliament of India. Article 52, there shall be a President of India. Article 74, there shall be a Council of Ministers. So these are all creatures of Constitution. So Parliament is the creature of Constitution, which is the creator. So creator is Constitution, creature is Parliament. Creator is equivalent to God and creature is human being. How can you imagine that the creature, that the human being can meddle with the God? It is absurd. If you want to amend the Constitution, you make a Constituent Assembly and amend it. The Parliament, which is elected only to rule the country, has no powers to amend the Constitution. This was the decision given by the Supreme Court in Golaknath versus State of Punjab in 1967. Okay. Mrs. Gandhi, Indira Gandhi, returned to power with thumping majority, 1971. She brought out 24th Amendment Act. She changed the caption of Article 368. Power and procedure to amend the Constitution. Secondly, she inserted a proviso in Article 13. Whatever amendments are made through Article 368 will not get the protection of Article 13. She made a provision in Article 368. By virtue of Article 368, the Parliament is competent to add, delete, modify any provisions of the Constitution. So, she has made every protective, insulated, every provision of the Constitution. That is, Parliament has been restored the powers of amending the provisions of the Constitution. This amendment was challenged, 17th Amendment, 24th Amendment, they were challenged in the Supreme Court in the very popular case, Kesavananda Bharati versus State of Kerala in 1973. Remember, 13 judges, 7:6, minority 6, majority 7. This is the case decided by the highest number of judges. In this case, Supreme Court declared that Parliament has absolute power to amend any part of the Constitution. But since the word used is amend, it can amend any provision, no doubt, but it cannot amend the basic structure of the Constitution. Then the question is, what do you mean by basic structure? Supreme Court, if you want to know about the basic structure, look at the preamble. So, preamble acquired importance in the Kesavananda Bharati versus State of Kerala case. So, in nutshell, as of now, Parliament has powers to amend any part of the Constitution without damaging the basic structure of the Constitution. In various judgments, the Supreme Court has enlarged the definition of the what is known as the the basic structure to include almost everything. Everything has been included. Parliamentary form of government, social justice, rule of law, everything has been included under the provisions of, under the ambit of the basic structure. So, coming back to preamble, the preamble as of now is part of the Constitution. And whether it can be amended? Yes, it can be amended. Whether it has been amended? Yes, it has been amended. 42nd Amendment Act added 3 terms in the preamble. One is secularism. Second is integrity. Third is socialism. Secular, socialistic, integrity. These 3 new terms have been included in the preamble of the Constitution on the recommendation of Swaran Singh Committee. And remember, these additional terms which have been incorporated in the preamble is nothing new. It is already there. Secularism is reflected in Article 25, 26, 27, 28. What is secularism? As far as religion is concerned, the state is neutral. It is neither anti-religious, nor irreligious, nor pro-religious. It promotes all religions. As in the matter of religion, it is a completely neutral. It does not, the secularism is something which deals with the man and the state, leaving the relations between man and the God to the individual. It always appreciates the reality of the unseen, but at the same time, it does not interfere with the religious principles. That is called secularism. It is already reflected in Article 25, 26, 27, 28. Then secularism, this is. Second is socialism, already included in the Constitution, Article 39B and Article 39C. Both small letters, Article 39B and Article 39C, reflect the socialistic principles. Already there, in the direct, though it is directive principles, it is already included in the Constitution. As far as integrity is concerned, what is Article 1 says? India, that is Bharat, is union of states. It is not a United States. It is union of states. The states have the powers, have the willingness to come. It cannot go back. Sikkim has associated. Sikkim was associate state. It has become a full-fledged state. It cannot go back now. It is one-way traffic. The states can come to the union, and from union it cannot go. So that is integrity. So nothing new in this. Now the question is, 2 things you should remember from the critical point of view. One is, the preamble says, we the people of India. We the people of India, there is a criticism. Because our Constituent Assembly was not elected by the people of India. It was elected by the members of the provinces of British India under the limited franchise. So how can you say we the people of India? Because it is not the we never represented in the Constituent Assembly. All our nominated members are elected through limited franchise. So that is question number 1. Second is, the Supreme Court has said that the Parliament has no power to amend the Constitution. Especially the fundamental rights. Parliament cannot amend the fundamental rights or any provision of the Constitution affecting the basic structure. Now there are 2 views. One view is, the Parliament has been given the powers, amending powers, and by virtue of this amending power, you cannot extend your limited power to unlimited power. So whatever Supreme Court has said is correct. But there is another point. So what is the Parliament? Parliament is the representative body of the people of India. 130 people vote and elect the members of the Parliament. If the members of the Parliament, which is the elected representative of the country, if you deprive them of amending the Constitution, it looks very odd. It is true. the amendment of the powers to amend the Constitution has been abused or misused or used allegedly by different successive different government, irrespective of the party affiliation. But one aberration cannot justify another aberration. One negative cannot justify another negative. So is it not proper time for the legislators to rise up and tell that Parliament should be restored with the powers of amending the Constitution fully? So that point, of course, you and I cannot argue. It is for the constitutional experts, and the judiciary should look into this. Thank you.